Hi.
Hi, I'm Linda Valdez, KNX. I wanted to share really quickly because I want you to comment on the Supreme Court's ruling that got rid of the temporary restraining orders. You know, ICE agents can come back into LA and basically argue where they are, what they look like, their language.
Yeah, and would like to and happy to answer any on-topic questions as well, but let me talk about that. I know it's top of mind for so many, including us in the California Department of Justice, who, as you know, we were an amicus in the underlying case here in the Central District of California, in which that the ACLU led, and in which a trial court judge found that it violated the Fourth Amendment for ICE agents, federal immigration officers, to use race, the inability to speak English, location, or perceived occupation, to use those factors in any one of them or in any combination to stop and detain, search, seize Californians. And I agree with that case. I thought it was well written, well supported by the law and the facts. And the federal government, of course, appealed that case, and the Ninth Circuit did not grant the federal government's request for stay. But then they went to the Supreme Court on what's called, the U.S. Supreme Court, on what's called the emergency docket. And today we got word that on the emergency docket, on a 6-3 decision, it appears the U.S. Supreme Court has stayed, provided an emergency stay on this case. And so it's disappointing, and the emergency docket has been used more and more. You often don't know who has voted how and for what reason. There's no argument. There's no written opinion. There's no statement by judges as to justices regarding where they stand and why they stand where they do. We did get a little glimpse into some thinking with a concurrence by Justice Kavanaugh on the emergency opinion, as well as a dissent by Justice Sotomayor, joined by Justices Kagan and Brown, and so Jackson, excuse me. And so we don't know the reason that the 6 judges decided on this. We may never know. But we do know, because he told us, Justice Kavanaugh's decision. And it's very disturbing. And I think Justice Sotomayor sort of captures where it leaves us if you follow Justice Kavanaugh's decision, again, which might not be the majority's rationale. And she says, we ought not live in a government or in a nation where the government can seize you because you appear Latino, because you speak Spanish, or because you appear to have a low-wage job. And I couldn't agree more. We shouldn't live in a country like that. And that's what the lower court's decision was about, making sure that we don't live in a country like that. And we'll see what happens next. This is, an emergency petition. The U.S. Supreme Court could have stayed out of it and allowed the lower court proceedings to continue, but they decided that they wanted to weigh in. I'll also acknowledge that the U.S. Supreme Court has recently said that you can't consider race in college admissions when it could be one factor among many to tackle historical discrimination, to address personal racial discrimination in an applicant's life. You can't consider it. But you can consider race when in a city like LA, where there are so many Latino Californians lawfully present, following the law. You can use race as a factor to discriminate potentially against Angelenos and Californians based on race. So how they prevent the use of race to tackle discrimination but allow the use of race to potentially discriminate is disturbing, and it is troubling. So those are some of my thoughts on the opinion.